They must have ended that discussion as soon as we were jumping in to try to listen to it, but there was an argument over the admissibility of some photos. We'll try to get some facts about that across to you in a couple of seconds. Andell Brown, we were talking about this being the second trial for this defendant, and from my read of the court's opinion that struck down the first conviction, you had ineffective assistance of counsel claims and claims that the state was improperly talking and about the defendant's right to remain silent. So two big issues that led us back to a second trial here today.
Yeah, Aaron, that is a very big issue because we're talking about one of the most fundamental constitutional guarantees that we have, which is the right to remain silent, and the state has to prove the case against you. You don't have to make a statement in your defense. And it appears from the order that there were at least 25 references by the prosecution to the defendant choosing to remain silent. The way the court looks at it, the way it's been interpreted by the Supreme Court, is that if someone chooses to remain silent, which is their constitutional right, you can't use that against them. You can't turn around and say, well, if they were innocent, they would have said so. That's an improper comment on silence, and it violates the Constitution. And his defense attorneys did not object to it appropriately. And the court said, look, you did the wrong thing, and we have to overturn this decision and send it back for a new trial.
Well, you know, one thing that's interesting that the state did yesterday is the state brought in testimony about this conversation that the defendant had about sports, football, things like that, when he was in the custody of deputies right after they showed up at the purported crime scene. And this was one of the grounds that the defense tried to appeal this case on, because the defense didn't like the prosecution in the original case basically trying to say, okay, well, that's evidence of guilt because a person who wasn't guilty wouldn't be trying to deflect the topic of conversation to football and away from his wife's death or something like that. Right. Now, the appeals court didn't latch on to that particular argument and turned around and said, well, you know, we're going to deny that particular claim for relief. And not surprisingly, the state brought it in a second time yesterday. What's your reaction to that?
Well, in the first case, the argument that was made on appeal was that his defense lawyers did not review the video of the interrogation before it was played. They didn't know what was coming. They weren't prepared for that. And that in the video, it was actually the detective that brought up football first and not the defendant. I think the prosecution is well within their rights to bring it back up again. It's on his defense lawyers to do their job, to cross-examine and to challenge the evidence for any inaccuracy. So I think it's a great strategy to bring it up again, and I think his defense lawyers should be on guard for any improper comments by the prosecution this time around.
Yeah, look, I mean, I've got no sympathy for the defense complaining about that, because the defense objected to it again this time around. But look, if the appeals court says that was okay in the first case, right, then they're probably going to say that's okay in the second case. The defense lodged an objection, but I don't see that one going anywhere. Bottom line is, if the appeals court says that particular issue, talking about this football game comment, things like that, if the appeals court says that's okay, it's okay.
Yeah, it's fine. It's something he chose to talk about. It's something that happened, and it goes to the ultimate issue that is in this case is his demeanor the type of demeanor someone would have when their wife has just been accidentally killed. They're saying his demeanor was cold. It was indifferent. He did not seem bothered or affected by what had just happened, and that was because he intended for her to die, and it was not an accident.
What do you make of the defense case here? The defense has to get over a couple of big issues, one of which I think it's the elephant in the room is the statement or the series of statements the defendant made in the 911 call saying he shot his wife. How does the defense try to get over that?
Well, they've indicated that he was in a state of shock. He was inebriated. He even made a mistake of dialing 411 instead of 911. So the defense is coming at it from the perspective of, this is a man who's in shock. He just lost his wife. It's a terrible, tragic accident, and he's not thinking straight. He's been drinking. Other things like that have been going on. So you can't take what he says literally. That's where they're coming from. But I think that's a significant hurdle, as you said, Aaron, for them to overcome.
It's tough, but it's not impossible. And I think that they're trying to characterize it about as well as they can. Some of the things coming out of the state's witnesses in this case seem a little bit unbelievable. We just had a witness on the stand before the break saying, well, she didn't think there was any way to fire the gun without holding the handle of it. Well, I mean, gosh. It would seem to me that, you know, if somebody's grabbing onto the barrel, they could hit the trigger. I mean, I know it would be hard, but I mean, theoretically, it's possible. So some of what's coming out of the mouths of the state's witnesses just seems a little bit strange. What do you take of that?
I think it does, and once again, it's up to his defense attorneys to take the state to task for their witnesses' testimony. If the testimony is inadmissible or they're making an impermissible inference from the evidence, then they have to make the objection. If they're testifying on something they could not possibly know, his defense lawyers have to make that objection. So, and they have to keep those things in mind when it comes around to closing argument time, to point out to the jury that the state is overselling its case through witnesses that are testifying about things that aren't absolutely true.
Yeah, this will be an interesting one to follow. The defense really has to stay on its toes in this particular case because a lot of this is going to boil down to characterization of evidence as to whether or not the evidence is going to back up that it was the defendant who pulled the trigger or whether this was a suicide attempt. I want to play that 911 call because we were just talking about this being one of the hardest hurdles for the defense to get over in this case.
Emergency.
I just shot my wife.
You just what?
I just shot my wife.
Where's your wife?
She's right here on the floor. Please send somebody at 5277 Isleworth Country Club Drive.
5277 what drive?
Isleworth Country Club Drive.
Okay, I just not giving me if I'm coming up.
5277 Isleworth Country Club Drive.
Firework?
Yes, Isleworth. ISLEWRTH.
Okay, what's going on there?
I just shot my wife.
You just shot your wife?
I shot my wife. Yes, please send somebody over.
Stay on line with me. Let me add the fire department. Don't hang up.
I will.
Where's the weapon at, sir? Orange County Fire Rescue. The address of your emergency? 44.
5277 Isleworth Country Club Drive. Hello?
I'm here. Hold on just a moment.
Oh, I don't know why. I'm sorry.
That's all right. It's 1, 2, 5,
No, it's 5277 Isleworth Country Club Drive.
I'm there.
I just shot my wife.
Okay, where's the weapon?
It's in the,
Yes.
I'm sorry.
Where is she breathing?
No, she's dead.
You know that for sure.
I think so, yes.
Okay, sir. Where is the weapon?
It's in the nightstand next to the master bedroom. And I'll be glad to meet the officer that's on door.
Where is your wife, sir?
She's on the floor in the master bedroom.
How old is she?
She is 1954, what is, whatever it is. Born in 1954.
Okay, you're sure she's not breathing or?
She's dead. She's done. I'm sorry.
Okay. Sheriff's office, you're on the way? Yes, we are.
Thank you.
Okay, sir.
I'll be at the front door. It's fine. There's no weapon. I'm fine.
Okay, so we're on our way.
Thank you so much.
Sir, you need to stand up for me, but I just start to hang up. Please.
I'm sorry, say again?
Sir, did you purposely do this?
No,
Or was it an accident?
it was an accident.
Stay on the phone with me. Do not hang up.
I won't.
Yes, sir. I'm here. And the gun is secure, sir?
I'm sorry, say again?
You do have the gun secure, correct?
Yeah, it's next to that in the nightstand. The gun is secured, yes. It's not a problem now. So I'll be sitting on the front step.
How long ago did this happen, sir?
I'll be 5 minutes ago. I'm on the front steps.
You're out on the front step?
Yeah, I'm on the front steps.
Okay.
I'm making the front gate from the front steps to go upstairs and find Diane. There.
Yes, how old is your wife?
1954, so let's see, whatever that is now. She's 55.
Is that the only weapon in the home, sir? Sir?
Yes, yes, I think it is. There may be one more like that that's downstairs. I'm not certain.
Okay. What, the gun just went off, or what happened? What exactly happened?
The gun just went off.
Where was she shot at? Where's the wound?
I don't know where it is.
Okay.
This is awful. You see it on the floor, and I don't know how it happened.
Where is she at in the house?
Again,
Where is she at in the house?
she's in the master bedroom.
She is in the master bedroom also?
Yes. No, I'm downstairs.
No, she's in the master bedroom.
Yeah, she is.
Okay.
Yeah.
Yeah, I'm here. Stay on the phone with me, okay?
No, I'm fine. I think the fireman's now. I think it's first.
So what?
I think I was fireman here.
Okay.
Yeah, his son. I'm here at 20 and I think the others on past me. Yeah, they're just passing me. Tell me back up.
Did you see the deputy?
Yeah, I see lights, but then tell me back up. I can back up.
Okay. Can you step down and wave?
Well, I'll try to wait. You might back up. No. Yeah, right.
Yeah, I'm here.
Hey, guys, over here. Over here. Yeah, right in the street. Just trying to get you.
Are you still on the front step?
No, I'm walking toward the street.
Where are you walking towards?
Toward the street because they're...
Folks, the jury is still out of the room in the millionaire murder trial, but the judge is on the bench and she's discussing with attorneys whether or not she's going to allow certain photos to be used as demonstration aids, not exhibits. An issue over whether those photos have been edited. Let's listen. Our feed from the courtroom froze up, but as you heard, a debate about whether or not images of the way the gun goes off are acceptable to be shown as demonstrative aids in front of the jury. Again, the state doesn't want to submit them as full-blown evidence, and the defense has an issue. It sounds not so much that the images were manipulated, but whether or not they were lightened or darkened. So this is just really simple photography technique. And it seems to me that the defense is making a mountain out of a molehill here. Andell Brown is an attorney, and he remains on the line with us. Andell, this, in my opinion, and I've been a photographer most of my life, is just almost pointless to argue about, because every time you make an image of something, you can alter the lightness or darkness of it. You can do it in the initial exposure. You can do it in old-fashioned photography when you make the print, and in modern photography, you are altering it every time you look at it because every monitor is set differently. So, you know, it's not like they were taken, you know, and like adding overlays to the image to make it look like more stuff comes out of the barrel of the gun than it normally did. They're just lightening and darkening so you can actually see what's there. Well, that's no different than changing the exposure on an image. I just don't see this going anywhere for the defense.
It seems like they are making a mountain out of a molehill. In this, you want the best evidence, and the question is, does this evidence or does this picture accurately depict the event that it's showing, which is whatever happens when they fire a bullet out of this gun? I think you want to present the best evidence, and if lightening an image helps you to see clearer what's going on, I think that's actually the purpose of giving the best evidence to the jury and making it a demonstrative aid. I don't see any reason the judge would exclude this evidence. I think it's coming in, and it's coming in just the way it is.
Yeah, so what's the purpose behind not submitting this as a full-blown exhibit, but rather as a demonstrative aid?
I'm not sure what the prosecution is thinking, because I think the judge gave them the indication in her analysis that if they wanted to introduce it into evidence, it would come in.
Yeah.
And we could just kind of end the whole argument there.
Exactly. I mean, I get that it's not something that was collected from the scene itself, but seriously, I mean, if it helps the jury understand the way that this particular gun fires or how much gunshot residue is propelled in an average, if one can use that term, firing of a projectile from it, then, you know, let it in. I mean, just let it in. It's not, you can argue about it after the fact, but it's a picture of a bullet coming out of a gun, you know? I mean, it's not, I'm not getting at why they're making such a big deal about it.
Yeah, it's a very objective piece of evidence. I don't see what the big deal is. I think it's best to kind of just move on and make your arguments about whatever you think that is going to show in relationship to your theory of defense or theory of prosecution.
Exactly. So we're waiting to see when things pick up again in court here. They were in the midst of this evidentiary dispute here, and we may not have a stream coming in, but it seemed, as you said, Andell, that the judge was relatively keen on admitting this. So, you know, when the judge sort of tips her hand at the decision she's going to make before she makes it, it's sort of an argument in futility, I guess one could say.
I mean, perhaps they want to lay the record if they believe the judge's decision is incorrect, to make sure that the appeals court can see what the nature of their argument was, whether or not the judge agrees with them. So I can understand that. I just don't think that this is really something that has a lot of teeth in it, because all they're saying is that we enhance the image, and enhancing, blowing up images, sometimes lightning, is something that happens to evidence all the time to make sure that you can make sure the jury has the best possible piece of evidence. Now, it doesn't change it. It doesn't make it show something different than what it originally showed, and that would be an argument if it was altered in any way, if it altered the substance of what was going on.
Yeah, let's go back to court now. The attorneys are just going over the credentials of the witness who's been on the stand. This was outside the presence of the jury. I suspect that it still is, but we'll double check that. Here's court. Welcome back to Law and Crime. I'm Aaron Keller. Andell Brown is our guest this afternoon. He remains on the line. Andell, this is a case where we're listening this afternoon about all of this stuff involving the weapon, the murder weapon, if we're to believe the state's characterization of it. But it seems to me that this case is going to hinge on one of two things. It's going to, or both of them, I should say. It's going to hinge on whether or not the jury believes that this defendant's wife was indeed trying to commit suicide, and there are some facts to back up that that might have been the case. They're going to focus on that, and they're going to focus on trajectory. And it seems to me that that's really the key evidence here. Not so much that the bullets came from this gun. That's what we're in right now.
Right. It appears that that's just preliminary foundational evidence that the fact that the bullet came from the gun. I think everyone agrees that it did come from the gun. But as you rightly pointed out, I think it's a lot about the trajectory and where the gunshot occurred from, because the distance between her face or her head and where the gun was actually shot from is very telling. Someone does not commit suicide aiming a gun from 18 inches away from their face, or whatever the number was that the prosecution is saying. They're saying that distance is consistent with someone else aiming the gun, not you aiming it at yourself. Suicides are typically conducted at close range, and the ballistic evidence should reflect that, whether it's stippling on the skin or from the gunshot residue. We can tell where the shot came from, as well as the trajectory. The trajectory seems to be very head-on from the evidence we've heard, and it appears to go in right between the eyes. So that is a question that's supposedly being answered by the prosecution, and the defense is going to have to rebut that. If they're saying it's an accident or a suicide attempt, they were fighting over the gun, then they have to explain why the shot occurred from where it occurred.
Well, I agree with that, but here's the thing. The gunshot residue is on her hands, not his, as I understand it. Now, granted, he was, down on the ground when they were arresting him, but still, the bulk of the evidence would seem to support that she had the weapon. Okay, we know that she also was presumably, if not drinking, then possibly intoxicated. Her blood alcohol level in the documents I've read says it was at about 0.113. And she also was mixing alcohol with prescription antidepressants that were in her system at 4 times the normal limit. Now, you start adding weapons and alcohol and antidepressants, and you have a dangerous mix. The defense has already talked in the previous case that that mix can result in violent or suicidal behavior. So you add all those things up, and not only are they injecting reasonable doubt, but the defense is injecting a theory, an alternate theory that they can point hard facts at.
Right, and I think the defense is doing a great job by doing that, and that's your job as the defense attorney, is to point out anything that leads to reasonable doubt or an alternate theory from the prosecution's hypothesis. In this case, where the gunshot residue is on her hand and other things like that, those are the facts that the defense is going to hammer home. When we look at what's going on here, we also have to take into consideration his reaction and his own statement about shooting his wife, which is what the prosecution comes back with, as well as his uncanny reaction to actually having witnessed the death of his spouse.
Yeah, this is really going to be a tough one, I think, for the jury to wrestle with, because if I were sitting on the jury, I'm not sure where I would go. His statements, in and of themselves, are pretty damning, because there's a presumption that some of his first words after the event might be the most truthful.
Right. And Aaron, if you're on the jury and you're not sure where you're going to go, that sounds like reasonable doubt to me, and that the proper verdict probably should be not guilty in that case. If the state hasn't removed the reason to doubt beyond and to the exclusion of a reasonable doubt, then not guilty is the proper verdict. If you're still guessing, if it's 50-50, if you're like, maybe I'll go this way, maybe I'll go that way, then it has to be a not guilty verdict. So the prosecution has the burden here. They have to overcome those things and convince that jury beyond a reasonable doubt that he is guilty of murder and this wasn't a tragic accident.
Andell, you're correct. We've got about 60 seconds here before we have to cut to something else. But again, the key here, I think, is going to be the trajectory evidence. That might flip my mind. And if indeed members of the jury are on the fence, it might flip the jury's mind as well. Absolutely.
Juries love the CSI evidence. They love that type of evidence because it's objective. They believe they can trust it. They're listening to the different arguments. They're listening to the different people that testify, but they want evidence that they feel like they can really rely on to tell the truth about what happened, and there's no spin in it. So the forensic evidence is going to be very important. The trajectory evidence is right up there at the top of the list.
Certainly, and that is yet to be coming down the path here in the millionaire murder trial out of Florida. It's going to be a case with a lot of back and forth, and I will give the law enforcement investigators credit. They really are going through almost every test possible that they could go through. We're going to take a break here on the Law and Crime Network. We'll be back with more analysis and, of course, the daily debrief in a moment. A bit of a surprise this afternoon. Court is going to run a little bit late in the millionaire murder trial out of the Orlando, Florida area. The judge has been pretty adamant that she wants to wrap things up before 5 o'clock every single day of this case, but today they're going to push a little bit late. So the court has taken about a 10-minute break. We're in the midst of it right now. And when they come back, we will bring you back for more live testimony. Andell, we have a forensics expert talking about the ballistics surrounding this weapon that is said to be a murder weapon, if we're to believe the state's version of the case. So as a defense attorney, how does one try to question a ballistics expert to get the defense theory out of that particular witness?
Well, here the defense theory is obviously that they're fighting over the gun and it goes off accidentally. In questioning this particular witness, you have to determine whether or not what they have to say has any effect on your theory. These experts, when they're in the foundational stages, there's really not much to question. They're more or less talking about the mechanics of the weapon. They're talking about, how these things operate, laying the foundation for further testimony that's going to come a little bit later as to what conclusions they've arrived at based on what they've observed. So I think as a defense attorney, you want to make sure that you're holding that witness to the standard of being accurate and objective in presenting the information. Once they start going into opinion, you want to be able to cross-examine and expose the fact that the opinion they're making may not be based solely on the evidence, but some preconceived notion that they have. So you want to make sure they're not making assumptions and jumping the gun, for lack of a better term.
Yeah, the defense has snapped back a couple of times when the state has tried to ask some of the crime scene techs for what sounds like an opinion about particular pieces of evidence. And we've seen the defense jump right in there and say, wait a minute, this isn't the proper person, this isn't the proper witness to ask that question of. And that seems completely reasonable as an objection. Look, I mean, there are forensic experts and there are crime scene techs who look over a scene, gather all the evidence, put it in boxes and bags, and then they bring it back to the experts for the testing. That's completely reasonable. So I'm waiting to hear what more of these experts actually have to say about some of these pieces of evidence.
Absolutely. The tech's job is simply to document, record, and collect evidence. They are not qualified to give opinions about what that evidence means. An expert has to be qualified as an expert by the court. They have to pass tests. They have to show that they have qualifications that mean that they are in a position where they can testify relevantly and with proper information about what's being talked about in court. Here, those techs, they don't have those qualifications. They should only be talking about the facts.
Let's talk about second-degree murder. This is a second-degree murder case, not a first-degree murder case in Florida. What does that tell us about the strength of what the state has and what the state needs to prove if the state's to get a conviction here?
Well, they have to prove that he took those actions illegally and that he did it with a depraved heart or an indifference to human life. Here they tried to, at least in the first trial, the way they tried to establish that was by his actions, by Bob Ward's demeanor, the way he danced and laughed with his daughter and another family member when they were speaking to him at the jail, the way he spoke with the detective about football, the fact that when he called 911, he seemed very nonchalant about the fact that he had shot his wife. So those are the things that they used to establish the depraved state of mind or the callous and indifferent state of mind of Bob Ward the first time around, and I assume they're going to do the same here.
This gets us into a discussion that we frequently have here, it seems, and that is this. Do people react to tragic events the same way, and is it really fair for people to sit on the sidelines and try to peer into their behavior and say, hey, look, that's odd, and therefore I'm going to attach criminal culpability to it? In other words, did the defendant engage in this behavior because he was guilty of something and he was trying to cover for it, or was he just trying to deal with a tragic situation by maybe masking some underlying pain?
Yeah, I think, Aaron, everyone would agree that everyone deals with grief differently. Not everyone is going to handle it the same way, and you should not infer guilt because someone handles it in a different way than you would. So I think there's a very strong argument for the defense to make that even though his behavior may be viewed as odd or not what you expect, it does not mean that he's guilty, and it should not be held up for a second-degree murder charge.
One thing that also occurred in this case, was the defendant's choice to invoke the right to counsel very, very early. In a lot of cases, we don't see that as frequently. We see the defendant talking and talking and talking, and they continue to stretch out the rope of their own demise. In this case, the defendant said some things that look incriminating, or that are incriminating, I should say, like the 911 call. Okay, but very quickly, he invoked the right to counsel. Now, legally, of course, you and I know that means questioning has to stop until an attorney's present. Not every defendant goes and does that and shuts down the police procedure. So where can we go with that? Was this guy, so he incriminates himself, but then he clams up very quickly.
Right. Now, the state may want to jump all over that, but remember the grounds for appeal was improperly commenting on silence, so they're really not going to get very far with that argument. And furthermore, he kind of switched roles at some point in the investigation from a witness to a suspect. And I think it's only right that at some point he should invoke his right to remain silent or his right to have counsel present while he's being questioned, because now he's being looked at as a suspect in this case. Furthermore, the detectives or the police officers involved, they have the obligation when they're changing roles from simply investigating what happened to investigating this person as a suspect to make them aware of their Fifth Amendment rights and their right to remain silent, Miranda, et cetera, et cetera.
It looks like we're coming back into court for more live testimony. The jury appears to be walking in right now as we speak. So, Andell Brown, I know we have to let you run because you have work to do, but it's always great to see you here on Law and Crime.
Thanks for having me.
Okay, let's cut back to court now. We remain covering the second-degree murder trial of millionaire Bob Ward in the Orlando, Florida area.